All right. Good morning. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, July 20th, 2022. The time is 9:30 a.m. With us today are Commissioners Emily Lindley and Bobby Janeka, as well as our General Counsel, Mary Smith, and I'm John Neerman. For those of you who are joining us virtually, please remember to keep your microphones muted when you're not speaking. For those who are making presentations, please wait to begin your presentation until either I or our General Counsel have asked you to begin speaking. On items where discussion or argument is allowed, we will inform speakers of their time limits. The registration closed at 9:30. It's now closed, but if you'd like to address the Commission on a particular item, please email agenda@tceq.texas.gov with your name, affiliation, and the item you'd like to comment on, and we will do our best to accommodate that request. And with that, I'd like to thank everybody for being present. And Ms. Smith, I'll ask you to please call the first item.
Item number 1 is consideration of the petition to revoke filed by 1817 Lacey Ltd., requesting an order revoking or suspending TPDS permit number WQ0015722201, issued to Sigma Pro Properties, LLC. The parties have been notified that the Commission will take oral argument on this matter. The petitioner, as movant, may speak first and may save part of their time for rebuttal. They should be followed by the permittee, the ED, and then OPIC. Each party will have 5 minutes to present their argument. And I believe for the petitioner, we have Mr. Casey Bell.
Mr. Bell, good morning. Good to see you, sir. Check that microphone. Make sure you have a green light on. If not, there should be a button that says push that'll get your light turned on.
It's on.
There we go.
Good morning.
Good morning.
Mr. Chairman, good morning. Good morning, Commissioners, Ms. General Counsel. I'd like to reserve 3 minutes for rebuttal.
Sure.
This is a very simple petition. There is no issue as to any of the material facts, and those facts are as follows. My client, who owns the property immediately adjacent to the wastewater discharge point and route that are authorized by this permit, was not provided notice of the permit application as was required by the Texas Water Code and by the Commission's rules. And that is because the permit holder provided false information in the application regarding property ownership by failing to identify my client as the owner of that adjacent property. This is a clear and significant violation of the Commission's rules. A very simple, a very basic search of the Tarrant County Appraisal District online records would have revealed my client as the owner of this adjacent property. Therefore, the permit holder also misrepresented in the permit application that the Tarrant County Appraisal District was the source of the landowner information that was provided therein. Had my client been provided the notice to which it was legally entitled, that is fundamental to the permitting process, it would have made comments opposing the application and would have sought a contested case hearing on the application as well. Instead, it was wrongly deprived of these fundamental rights, and as a result, the discharge that is allowed by this permit has and continues to directly and negatively affect my client's property, as was more described in Mabel Simpson's affidavit that was filed with our petition. That includes ponding of the wastewater on their property and foul odors emanating from those ponds. None of these facts are in dispute, and they are the only facts that are relevant to the Commission's decision on this petition. Good cause has clearly been established for issuance of an order today revoking or suspending this permit. Thank you.
Thank you, Mr. Bell. Any questions for Mr. Bell? Thank you. And I think we're going to hear next from Mr. McCarthy. Good morning, sir.
Good morning, Commissioner. Mr. Chairman. Commissioners, Chairman, my name's Ed McCarthy, and I am here on behalf of Sigma Pro Properties, LLC, the permittee. The facts are not as clear as Mr. Bell would have you believe, and they are not as straightforward. It is true that mailed notice was not sent to 1817 Lacey. That was not the result of any intent, any mens rea, or any plan to deprive Lacey of the opportunity of notice or of hearing. Constructively, I believe Lacey did receive notice. Notice was published twice, the notice of the application and later of the preliminary decision of the executive director. That is out there. In addition to that, a very important factor that must be considered and must be taken in consideration when you decide whether or not there was intent and whether it was inaccurate information or false information, I think there's a big distinction there, is the fact that the permittee went in what I believe you would even consider to be above and beyond steps of a permittee with respect to downstream and neighboring property owners. Mr. Robert Bierman, a manager of Sigma Pro, at the direction of the owner, Mr. David Underwood, went and walked to each of the properties identified on the map. This included Lacey's property. The property was occupied, it was discovered, by two different entities who were tenants of Lacey. One is Premier Paving and the other is Klossner Instruments. Mr. Bierman had personal visits with those people at Mr. Underwood's instruction for the purpose of explaining the permit application had been filed, what the purpose of it was, and why the visit was being made, and that they would hear from the TCEQ. There was never an intent to hide this application. If there was, we wouldn't have mailed notice to all of the other property owners. We wouldn't have published the notice the way we did, and Mr. Bierman certainly wouldn't have gone and walked the properties. I believe it's important that the Commission consider these factors in looking at the draconian result that Lacey would have you issue. Lacey didn't raise this until 3 years after the permit was issued. The ponding is in part, as demonstrated by some of the exhibits included in our response, by the fact that they have built a dam and berm in the watercourse without authority from the Commission, without authority from the Corps of Engineers, in violation of both state and federal law. This is not a clean hands case that Lacey comes in and asks you to pull the plug and to shut down Sigma Pro and its ability to operate under the permit. In the 3 years it's had the permit, since it's actually been operating post-construction, Sigma Pro has been in compliance with the permit. The executive director and the commission staff reviewed the permit application, found that all of the requirements of Chapter 305 and other pertinent regulations could be complied with, and since then Sigma Pro has been in compliance with those. It's regrettable that we didn't learn about this earlier in the permit process. We did not have the opportunity contemplated by 305.66 to correct the error when it was discovered. Had we found out before the permit was issued, we would have had the opportunity to correct the filing with the TCEQ. We would have had the opportunity to provide the mail notice, and we would have had the opportunity, if in fact Lacey wanted a contested case hearing, to request it. But 3 years after the permit was issued, there's no going back to that stage. So we do not have the opportunity, and therefore we're not in violation, or we didn't ignore the provisions of Section 305.66. So I would ask the Commission to consider all these facts. I know that the option here is to refer this matter to the State Office of Administrative Hearings to conduct a hearing and construct a record. I believe you have an adequate record, as Mr. Bell, I think, would concur, based upon the affidavits of Ms. Simpson on behalf of Lacey and the affidavits of Janet Simpson with the engineering firm, with the engineering firm, and of Mr. Bierman with respect to the activities that went on. I believe the Commission today could find that while there was a clerical error and a failure to send that mail notice, there was no intent, there was no mens rea, was no desire to hide or deprive Lacey of the opportunity of notice or hearing, that in fact Lacey did get notice to its tenants and through publication that it could have had the opportunity, and that the draconian result of terminating this permit or suspending it is not the appropriate remedy in this case. No one can go back 4 years to the Tarrant County Appraisal District website and find out what exactly was on there. I went on the website in this petition in drafting the response and reviewing the exhibits I was provided, and it's not as easy to manipulate. If you go to the property identification, you will find Lacey Properties identified. You will also find Premier Paving now identified as a tenant. I'm sorry if I could wrap up.
Go ahead, sir.
Okay. In conclusion, I believe there's a record here that would allow the Commission to deny the petition. If you decide to refer it to SOA, I would also ask that you refer it to ADR so the parties might have the opportunity to mediate. And finally, in closing, I apologize. I neglected to let you know that representatives of my client, Ms. Vivian Allen and Mr. David Speed, are here in the audience with me today, and I thank you for your time, and I'd be happy to answer any questions.
Thank you, Mr. McCarthy. I have none. Colleagues, any questions for Mr. McCarthy? Seeing none. Thank you, sir.
Thank you very much.
So let's hear next from the Executive Director's Office.
Good morning, Chairman Neerman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Michael Parr with the Environmental Law Division. With me today is Feroz Vahora of the Water Quality Division. After evaluation of the information, exhibits, and allegations in the petition and the TCEQ records for the Sigma Pro permit, the ED respectfully recommends the Commission refer the petition to SOA for a hearing based on the following relevant facts and reasons. First, as part of the permit application for discharging wastewater, applicants must identify the property boundaries of landowners surrounding an applicant's property, the property boundaries of the applicant's facility, as well as the property boundaries of all landowners adjacent to the discharge route for at least 1 to 2 miles downstream. The TCEQ Chief Clerk then is required to mail notice to landowners named on the adjacent landowners map and list, and that such information should come from current county tax rolls or other reliable sources. Adjacent landowners to a facility or discharge route are entitled to receive mailed notice of the application. Second, petitioner states that they are the owner since 2005 of 1817 Lacey Drive, the property immediately adjacent to the wastewater discharge point, and property number 4 on the adjacent landowner's map and list. Petitioner states that the discharge affects petitioner's property and alleges that the permittee falsely identified a different entity, Klausner Equipment, on the adjacent landowner's map and list as the owner of property number 4. Third, a review of the TCQ records for the permit and its application reveals that the English and Spanish public notices for the application were published in October 2018, January 2019, and February 2019, with the public comment period ending on March 11, 2019, with no comments received. Finally, TCQ records also reveal that the mailing list and mailing labels for the public notices just described do not identify petitioner as the owner of property number 4 on the adjacent landowner's map and list. Likewise, a review of the online records from the Tarrant County Appraisal District provided by petitioner identifies petitioner as the owner of 1817 Lacey Drive. Given that it appears that petitioner is the actual owner of 1817 Lacey Drive, or property number 4 on the adjacent landowner's map and list, it is likely that petitioner should have been included on the adjacent landowner's map and list. Additionally, had petitioner been afforded mailed notice of the permit's application, petitioner would have been considered an adjacent landowner and would have had an opportunity to submit comments on the application and request a contested case hearing to ensure that its interests were protected. Thank you for your consideration. We are available for questions.
Thank you, Mr. Parr. I have none. Colleagues, any questions?
No questions.
All right, let's hear next from the Office of Public Interest Counsel.
Good morning, Chairman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. I'm Amanda Pessinen for the Office of Public Interest Counsel. OPIC recommends the Commission find that petitioner 1817 Lacey is an affected person and refer this matter to SOA for a determination of whether there is good cause to revoke Sigma Pro's permit and whether there was sufficient mailed notice for the ED to approve the permit. Lacey argues, and OPIC agrees, that Lacey is affected by the issuance of Sigma Pro's permit because Lacey is an adjacent landowner impacted by the regulated activity. Lacey contends Sigma Pro provided TCEQ with false information regarding adjacent land ownership, which deprived Lacey, an adjacent landowner, of required notice of the application. Lacey has submitted documentation to TCEQ indicating that it, not Klausner Equipment as identified in the application, is, and since 2005 has been, the owner of Lot 4 depicted on the adjacent landowner map. Lot 4 is located directly across the street from Sigma Pro's facility, and the discharge route runs through the entire length of the property. A portion of Lot 4 also lies within the 150-foot nuisance odor buffer zone around the facility. In its response to the petition, Sigma Pro states that it made a good faith attempt to inform all adjacent landowners of the application. However, Sigma Pro makes no assertion that Lacey is not the owner of Lot 4 or that Lacey received the required mailed notice of the application. As explained in OPIC's response to the petition, Sigma Pro's misidentification of the owner of Lot 4 may constitute good cause grounds for permit revocation as a misrepresentation of material fact or a false or misleading statement in connection with its original application under the rules. Because there may be conflicting facts within the record, OPIC recommends this matter be referred to SOA for a contested case hearing so the parties may present evidence on whether there is good cause to revoke the permit and whether there was sufficient mailed notice for the ED to approve the permit. Thank you, and I am available for any questions.
Thank you, Ms. Pessinen. I have no questions.
No
Colleagues, any
questions,
questions? All right, Mr. Bell, you have reserved some time for rebuttal.
Thank you, Chairman. Just briefly, in the argument that was made by Permit Holders Council, they did similar as to what they did in their response to the petition, that is assert some facts that are outside the scope of this petition, instead of directly addressing the issue that is before you. Regardless of any efforts that may have been above and beyond what was typical to inform nearby property owners of this application, the permit holder still misrepresented the owner of my client's property in the permit application, failed to include my client's identity as an affected property owner, in fact, just across the street from this discharge point, and misrepresented that they used the Tarrant County Appraisal District records as a source of their landowner information. These are the operative facts. As was argued in their response, they contend that they made good faith efforts and there was no malintent or malfeasance here. They weren't trying to hide the petition. That's not something that we have to show as part of proving the grounds for revocation. That's just not in the rule. Regardless, the efforts and research that they may have put forth in that regard are irrelevant. What they should have done is do this search of the Tarrant County appraisal records, and those would have clearly shown that my client had owned the property since 2005. Misrepresentations regarding property ownership in the application may have been negligent, but they were misrepresentations nonetheless. Constructive and published notice are inapplicable here. The Texas Water Code requires mailed notice, and there was no constructive notice. There was no actual notice. There's an affidavit in the record before you from my client stating there is absolutely no notice provided. Counsel for the permit holder mentioned that they wouldn't have tried to hide this application because they mailed property owners, the other property owners, notice. And while that is true as to some of those property owners, there's evidence in the record that they actually, for two of the other property owners nearby, failed to provide the mailed notice required by the Water Code and the rules. There was some argument regarding the timing of our filing. The TCEQ can revoke a permit at any time based on the rule inapplicable here. They've known about this error in their application for almost 2 years, and yet they have failed to come forth to the TCEQ and inform the executive director of that error as required by the rules and the permit itself. With that, that's nothing further.
Thank you, Mr. Bell.
Thank you.
Colleagues, any questions or comments at this
thank you.
point? Okay. Thank you, sir. I think an ALJ is going to be in the best position to weigh the evidence. So, colleagues, I'm inclined to follow the suggestions of the Executive Director's Office and OPIC and refer this over to SOA.
Yeah, I would agree. I think there's a lot in the record, but I could still use a little more fact-finding to be in the record. And I will say, it was suggested maybe an ADR referral, and I would be supportive of that because I do think it's a limited amount of parties and hearings are expensive. And so if there's a way to, that they could get together and work that out, I would be supportive of including that in a motion.
I agree.
I have a motion then.
Let's hear it. I
Okay.
think we're ready.
I would move that we refer the petition filed by 1817 Lacey Limited requesting an order revoking or suspending TPDES permit number WQ0015722-001 issued to Sigma Pro Properties LLC to SOA for a contested case hearing on all the issues raised in the petition, and that we also refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with the SOA preliminary hearing scheduling efforts.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 2 is the consideration of the petition filed by Harrington Turner Enterprises LP for the creation of Collin County Municipal Utility District Number 7. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So colleagues, as you know, we review requests for contested case hearings on mud creation under Chapter 55, Subchapter G. So here we're looking for affected persons, but we do not, under these rules, need to identify individual referable issues. And with respect to the affected person analysis, I thought that the executive director and OPIC did a very helpful job. They were largely in agreement with each other, so I would adopt their recommendations to the extent that they are in agreement, and that would leave just 5 requesters, and those are Linda Fletcher, Jeffrey Dwight, Dan Shoup, Valita Logan, and Gabriella Tournay. And I think each of them, at least on my reading, articulated personal interests that are distinguishable from the interests of the general public. So I'm inclined to grant those 5. That's how I came out. Commissioner Lindley, what do you think?
I believe I'm in agreement. I was just checking off the 5 names.
So it's
I have,
Fletcher, Dwight, Shoup,
Yeah.
Logan, and Tournay.
yes, there were a lot of close calls on these, I will say that, but I'm comfortable referring those 5 in addition to the other names for a hearing.
I missed the point where you said the relatively large number of agreed parties and the extra 5. Yes, I'm on the same page as y'all.
Okay, and then there were some requests for reconsideration, and that's just a procedure that's not available under subchapter G, so I would deny those, and I think that disposes of all the issues.
I agree.
Are we ready for a motion?
Likewise, and I can attempt that motion.
All right.
I move that we grant the following hearing requests. City of Murphy, City of Parker, Mir Abbas Abidi, Elizabeth Abraham, Lance Caulfield, Don Wade Cloud Jr., Sherry Cloud, Jeffrey Dwight, Linda Fletcher, Catherine Harvey, Michael Haynes, Jenna Holton, John Holton, Jenny Jazadareja, Miriam Jazadaregia, Lisa Kester, Amy Lee, Valeda Logan, Angelique Lonkar, John Lonkar, Diane Elizabeth Lundberg, Edwin Lundberg, Andrew Malkzewski, Tom Marshall, Carolyn Mobius, Ashesh Patel, Heather Powell, Sumit Roy, Sylvia June Roy, Kimberly Ryan, Ashley Sakamoto, Ryan Sakamoto, Dan Shoup, Charles Spence, Gabriella Torn, Sunil Unakrishnan, Sri Lakshmi Unakrishnan, Tom Weiss, Linda Weiss. I further move that we deny all remaining hearing requests and all requests for reconsideration, and move that we refer the matter to SOA for a contested case hearing on the petition.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 3 is the application by the Port of Corpus Christi Authority of Nueces County for water use permit number 13630. The parties have been notified that the commissioners will not take oral argument but may ask questions. Those who have signed in will be noted for the record.
So colleagues, here we have another set of subchapter G requests, hearing requests, and they include 2 associations and numerous individuals. There's one set of individuals that just simply failed to articulate a personal justiciable interest, so we'll have to deny those. The remainder of the individuals express either a recreational interest or an economic interest. And for those who expressed an economic interest, I couldn't find an explanation of how the regulated activity, and in this case, that's the diversion of water, would cause personal harm. There were some arguments made about water quality, but that's outside the scope of our review on this type of an application. So the economic interest claims just did not get me there for an affected person determination. Similarly, on the recreational interests. I thought overwhelmingly that they failed to rise to the level of a personal justiciable interest, with one exception. I thought Mr. Serna, his request stood out. He provided enough specificity. He had demonstrated enough of a connection to this particular location in the bay. He explained a recreational interest that went beyond the interests of the general public, in my view, so I would grant his request. Turning to the two associations, the relevant issues are whether the issues under the application are germane to the organization's purpose, and whether the association has identified at least one member who would have standing in their own right. And in this case, I thought that the Ingleside on the Bay Coastal Watch Association did meet those tests, importantly because that association identified Mr. Serna as a member for purposes of standing. The Coastal Conservation Association, however, did not identify a member who would have standing in their own right, so I would deny that request. So the bottom line on the affected person analysis for me is that I would grant Mr. Serna and Ingleside on the Bay Coastal Watch Association, and I would deny the remaining requests. And again, we don't have to identify issues on this referral, but I would include an ADR referral as part of this package.
Well, I mostly agree. This one was really hard. I think we've had a lot of tough calls today. This one was very difficult for me, but I will say how it came down is I did not find Mr. Serna's hearing request specific enough for me to see how he is personally affected, different than the general public. So, that for me, that's not granting a hearing to him, which would also, mean not granting a hearing to the association, which means that I would deny all the hearing requests and move forward. So that's how I came down on it. And I might be different than you two, but there's that.
Fair. That's fair. That's why there's three of us up here voting.
I think
Commissioner Janeka.
we're sending more work to SOA. I came down the same way that Chairman Nierman did. I think and I appreciate your description of some of the parties' request on the basis of recreational interests and where they described where they recreated, how they perceived the impacts. I noted a lot of room for confusion here, where there seemed to be multiple different permits and other entities and applicants that the public appeared to be really concerned about. And I think that in reviewing this specific to the authorization unique to this item, this matter, a water right or diversion rather than a discharge or another type of a agency authorization, I think that really informed my decision-making here. And I also arrived at the conclusion that Mr. Serna's description of the locations that he and his family recreated and actively fished and that those descriptions in relation to the intake point in this water right diversion really moved it for me. So I'm comfortable moving forward with a motion with referral to SOA.
I think I'm ready for a motion.
I move that we grant the hearing requests of Encarnacion Serna and Ingleside on the Bay Coastal Watch Association, that we deny all remaining hearing requests, that we refer the matter to SOA for a contested case hearing on the application, and refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with the SOA preliminary hearing scheduling efforts.
The motion has been made. I second it. All those in favor say aye.
Aye.
Aye. All those opposed say nay.
Nay.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item 4 is the application by Oxy Vinyls LP for a major amendment of Texas Pollutant Discharge Elimination System permit number WQ001539000. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So colleagues, we were just talking about the affected person analysis for associations, and on this item, we have a single hearing request. It is by an association, but the request does not identify a member of the association who would have standing in his own right, so I would deny this request for a hearing.
I'm in agreement.
Likewise.
I think we're ready for a motion.
I would move that we deny the hearing request of Bayou City Waterkeeper, that we issue the major amendment and renewal of Texas Pollutant Discharge Elimination System Permit Number WQ000153900 to Oxyvinyls LP as recommended by the Executive Director, and that we adopt the Executive Director's response to comments.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 5 is the consideration of a resolution appointing 6 nominees to the Water Utility Operator Licensing Advisory Committee. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. I'm Haya Zeman, the Deputy Director of the Occupational Licensing and Registration Division, on behalf of the Executive Director, and with me is Alicia Ramirez with the Environmental Law Division. We are here today to request the Commission's consideration and approval to appoint a total of 6 individuals to the Water Utility Operator Licensing Advisory Committee, also known as WULAC. These recommended appointments will replace advisory committee members whose terms expire on August 31st, 2022. 2 of the nominees are reappointments, Joseph McDaniel and Corey Moose, and the other 4 nominees are new appointments and include Harold Burris, Angel Bustamante, Melissa Lloyd, and Raymond Perez. If approved, these terms will run from September 1st of 2022 through August 31st of 2026. WULAC consists of 13 members who represent various water and wastewater regulated entities from diverse geographic areas of the state, ethnic groups, businesses, government entities, and associations. WULAC's sole duty is to advise the Commission regarding water and wastewater operator licensing and training issues, and to facilitate communication between the Commission and the water and wastewater utility industries. The WULAC has no executive or administrative powers or duties with respect to the operation of the Commission, and all such powers and duties rest solely with the Commission. A notice of request for nomination to fill these vacancies was published in the January 28, 2022 issue of the Texas Register. An email solicitation was also sent to all individuals who hold a current TCEQ water license or a wastewater license, and current members were asked to recommend potential members. The Occupational Licensing and Registration Division received a total of 45 nominations. After a thorough review of all the nominees, and making a reasonable attempt to provide balanced representation, staff is recommending the appointment of 6 nominees to the advisory committee. These 6 recommended nominees would balance the representation across the state with current members with respect to geographic location, technical background, and affiliations with associations, government entities, or training providers. In conclusion, staff respectfully requests adoption of this resolution. And thank you, and we're available to answer any questions.
Thank you. I have none. Colleagues, any questions?
No questions, thanks.
Ms. Smith, has anyone signed in to speak?
No one signed in on this.
Mr. McWhorter?
OPIC recommends approval of the resolution regarding appointments and reappointments to the Water Utility Operator Licensing Advisory Committee as presented by the Executive Director.
Thank you. I agree with that. I want to begin by thanking the committee members for their service. I want to thank all of the nominees for their willingness to serve. And colleagues, I think I'm ready to move forward with this.
I agree.
Likewise, I want to compliment your office as well, Mrs. Zeman. I called the general helpline earlier this week with a question from a friend of mine who's a former water operator in Texas who's moved out of the state and wants to keep that license around. And the help was immediate and on point, answered all my questions. So I hope to continue to have the good input from the industry to make sure that tedious process we put our water operators through continues to be, meet their needs. So I will make the motion that we appoint the following nominees to the Water Utility Operator Licensing Advisory Committee effective September 1st, 2022, for a 4-year term to expire August 31st, 2026. Harold Burris, Angel Bustamante, Melissa Lloyd, Joseph McDaniel, Corey Moose, and Raymond Perez.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next items.
That takes us to our enforcement docket, which is items 6 through 39, and the executive director's staff is here to present these items.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Susan Jablonski, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division representing the Executive Director. Pending and before you are items 6 through 39. The total assessed administrative penalties are $530,410, with $71,877 deferred, $53,196 applied toward supplemental environmental projects, and $405,337 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Colleagues, any questions?
No questions.
Ms. Smith, is anyone signed in to speak?
On items 6, 9, and 37, we have representatives of respondents who have signed in and indicated that they're available to answer questions, but haven't asked to address the commission.
Okay, appreciate that. Mr. McWhirter.
My office reviewed these items, and we recommend approval of the orders as recommended by the Executive Director.
Thank you. I agree with that, colleagues. I think I'm ready to move forward with the docket.
I am as well. I would just note item 13, I believe. Double checking now that I say that.
Yes, ma'am.
Yeah, I would just encourage the executive director to, I don't know, it seems like they continue to have ongoing issues. And so just to, I think they deserve more scrutiny. So hopefully they're not in front of us anytime soon, but should they continue to have issues, it almost seems like they're right on the line of being sent to the AG's office. So encourage you to just scrutinize them heavily, because anyway, I'll stop there.
Thank you, Commissioner Lindley. I second that. I won't be upset if that quickly moves along and it doesn't seem to be moving in y'all's estimation. Thank you.
I can make a motion, though, since I was going to do that as well.
Please do.
I move that we adopt items 6 through 39 as recommended by the executive director.
Second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item 40 is the consideration of the monthly enforcement report, and the executive director's staff is here to present the report.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me are Susan Jablonski of the Enforcement Division and Gitanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2022 through May. There were 745 effective administrative orders issued, and of those, 110 contained supplemental environmental projects. These orders assessed a total of $9,361,089 in penalties, with a payable amount of $5,590,494. $2,194,863 are to be paid towards supplemental environmental projects. 11,081 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 1,459 enforcement action referrals have been received. There are 1,948 pending administrative orders, with 477 cases that are on the backlog. 207 cases are pending at the Attorney General's office for representation in district court, and 11 judgments have been issued. 2,022 cases are being tracked for compliance. We have included for review a summary of OCE investigative activities for fiscal years 2020, 2021, and 2022. We are available to answer any questions you may have.
Thank you. I have none. Colleagues, any questions?
No questions, thanks.
Has anyone signed in to speak?
No.
Mr. McWhirter.
I have no questions. Thanks for the report.
And no action is necessary, so we thank you for the report. And Ms. Smith, when you're ready, please call the next item.
Item 41 is our public comment session, and we have no one signed in to speak at this time. We will pause to see if anyone jumps to the podium.
I have a public comment. This is the last agenda that we have two retirements, Earl Lott and Dr. Mike Honeycutt, and I just wanted to take the opportunity to thank each of you for your many years of outstanding service. We will miss you. We're happy for you. And Earl, I want to share, we had a little customized celebration in your honor at my house. We've had fun with Beyonce's Who Runs the World, and in our house it's been squirrels, because squirrels really do run the volume in our house when our dog starts barking. But in honor of your retirement, Lucy overheard me talking to you, and she decided that it's the Earls who run the world. So anyway, our family tribute to you, Earl. Colleagues, you want to bail me out?
Well,
Add anything
that's
else?
hilarious. I will not give Earl that kind of credit. Dr. Honeycutt, absolutely. No, yeah, I mean, I love both those gentlemen. It'll be weird to not have them around. They've dealt with so many issues over the years, not easy ones either, a whole lot of controversial stuff, and they've carried them well, and they're leaving very big shoes to fill. So I'm gonna miss those two guys, and always giggle now when I hear Beyonce.
Likewise, thanks for ruining my entire Beyonce playlist on my running CD. I really can't appreciate either of y'all enough, and can't add on to my colleagues' comments. I think state employees at the time of retirement, we always like to celebrate the endurance quality, but there's an eagerness quality as well, and that's another dimension that y'all really bring in spades. And I think our agency is going to be a little worse off in a lot of ways that we'll continue to find in new surprising ways as y'all depart and find much more time in your days, and hopefully have time to catch up on all the things you've been putting to the side as you've really prioritized public service to the state. So thank you so much for that.
Earl, Mike, thanks again for everything you've done for the people of this state and this agency. We really appreciate it. And Ms. Smith, with that, I'll ask you to please call the next items.
Items 42 through 45 are for closed session, and the commission will meet in closed session today. We'll be meeting in Building E, Room 211S at, should we give ourselves 5 minutes? 10:18.
And with that, the time is 10:13 a.m., and we stand in recess.
The commission, The commission met in Building E, Room 211S for closed session from 10:19 until 10:46 a.m. on item numbers 43 and 44 as posted in notice pursuant to Texas Government Code, Section 551.074. No action was taken. The agenda stands adjourned. The time is 10:50.